U.S. Attorney, this is David Perdue. We met the other day.
Yes.
I'm a senator from Georgia.
Yes, thank you for your time.
I want to thank you for your perseverance and patience with us today. I hope it wasn't anything I said that cleared the room for you. I hope you're doing well.
I hope it wasn't anything I said.
Well, thank you so much for, again, your perseverance. I just want to join my colleagues and welcome you before the Judiciary Committee, and also thank you for your years of public service. As we talked the other day, I am very impressed with your career and want to thank you for upholding the law in your career. I congratulate you on this nomination. You spoke about this morning your oath and the required commitment to the Constitution. I applaud that. You've demonstrated that in your career. You were just talking about mandatory minimums, if I'm correct. I just have a quick question relative to a case that you had in your jurisdiction recently. I want to ask about a defendant who was convicted by your office in the late 1990s. His name was Francois Holloway, I believe. I hope you remember him. There was a lot of press coverage on this case during your current tenure as U.S. Attorney. In 1995, Mr. Holloway rejected a 10-year plea and was convicted after a trial on 3 counts of armed carjacking and possessing a gun during a violent crime. Those offenses subjected him to consecutive mandatory minimum sentences, and he received a total of, I think, 57 years. In 2013, Judge Gleason, the district judge in Brooklyn, who sentenced Mr. Holloway, began what the New York Times called a campaign on Mr. Holloway's behalf and wrote to you asking that you consent to an order vacating 2 of Mr. Holloway's convictions for armed carjacking. No one argued that Holloway was innocent or that he was wrongfully convicted or that his sentence was unlawful. No one claimed that there was a problem with the trial. All of Mr. Holloway's appeals were rejected. The case went to the Supreme Court, which upheld the convictions. In fact, everyone agreed that the sentence he received was lawful under Title 18 of the Sentencing Guidelines. Judge Gleason didn't agree with the sentence the law required him to impose and was asking you to help him do it. In February 2013, to your credit, you refused to vacate the carjacking convictions. You suggested to Judge Gleason that Mr. Holloway could contact the office of the pardon attorney and submit a petition for commutation of his sentence. I personally think that that was the appropriate response. I congratulate you on that. I think every prosecutor would have responded that way. In May of 2014, however, Judge Gleason again urged you to vacate 2 of Mr. Holloway's armed carjacking convictions. He said your suggestion that Mr. Holloway seek clemency was not a realistic avenue of relief because the fact that Holloway committed crimes of violence will disqualify him. The judge was definitely a passionate advocate for this defendant. This time, however, you backed down. You consented to the judge's order to vacate the carjacking convictions. I want to note that he was a violent offender, along with an accomplice, stole 3 cars at gunpoint. You know, as the top law enforcement officer, I have a couple of questions relative to that case and your perspective 10 years as Attorney General. My first question is, what caused you to change your earlier position in that case?
Senator, with respect to the Holloway case, it was a matter that had been of longstanding, it was a longstanding case from the office. It did predate my tenure, my first time as U.S. Attorney, my second time, but not my first time as U.S. Attorney, I should say. And it was a case in which it was the defendant who had made a motion to allow the judge to revisit his sentence. So there was, in fact, a judicial proceeding before the court at that time, and the court wanted us to take a second look at it. We did consider it numerous times. Ultimately, the matter was before the court, and while the judge indicated he would like to have the opportunity to review that, our view was that we had to look at the case consistent with many of the initiatives that were being put in place now by the Department of Justice, certainly with respect to clemency and with respect to how we look at offenders who have served a significant time and whether or not they would be eligible for that. Of note to me, as I reviewed the matter, was that Mr. Holloway was the second person in that carjacking incident, and in fact was not the individual with the gun, but was, of course, legally liable for that. And while he received the sentence of 57 years, the, shall we say, the main actor in that received a sentence shortly under 2 years. So there was an incredible disparity in the sentence there. But the real issue for us was there a legal proceeding in place? And there was. And essentially, did we have the ability to let the judge review this sentence again by keeping it in the court system? And we felt that we did. But before we did that, it was important to me to consult with every victim in that case. And certainly, we found all of the victims but one, after extensive research, all the victims who also felt that the judge should have the opportunity to reconsider Mr. Holloway's sentence without a guarantee of what that sentence would be. Based on that information, based upon Mr. Holloway's record in prison, based upon his role in the offense, we looked at how we would have handled the case under current times. And again, given that there was a court proceeding, we were able to go to court and tell the judge that we would not stand in the way of him reviewing the sentence again, which Judge Gleason did. Mr. Holloway was resentenced. He then went into state custody to finish a matter, and so I do not know his current status. But we did essentially allow the judge to take another look at that, and through the judicial process, the judge imposed a different sentence. That sentence was still significant, and it was still, I would say, twice as long as what Mr. Holloway would have gotten had he accepted a plea deal.
Thank you. You know, as the Attorney General, you'll have great discretion, just as you did as District Attorney. The question I would have is illustrated by that case, I think, is, you know, where do you draw the line? How do you see this balance between the law and your personal position in a case, your personal opinion in a case?
Senator, I don't believe that my personal opinion is the governing factor in a case, be it Mr. Holloway's case or be it any case in which I would review either as U.S. Attorney now or should I be confirmed as Attorney General. I will take a look at every case, and I will commit to you that I will review every matter brought to me with a full and fair examination of the facts and an application of the law, but also with a view towards, as in Mr. Holloway's case, whether or not there is a judicial proceeding there and the current status of that. But we will take every effort, and I will make every effort, should I be confirmed, to always act consistent with the law.
Thank you. There are just one last question on this in this vein. There are probably hundreds, if not thousands, of violent offenders in our federal custody who are serving sentences based on consecutive mandatory minimums that you just spoke about, like those imposed on Mr. Holloway. If you're confirmed and during your tenure as Attorney General, it comes to your attention there are cases like Mr. Holloway's, would you consent to early release of those offenders?
Senator, it would not be my place to consent to an early release, nor was it our place in the Eastern District of New York in the Holloway case. Our posture was to consent to allow the judge to revisit the sentence and impose the sentence that as a judicial officer he felt appropriate. So as U.S. Attorney, I would not be making the decisions as to whether someone should literally be released. Should I be confirmed as Attorney General, I would not be making those decisions either, except as people go through the clemency process or the pardon office, and those matters come under review by the Department of Justice. We would then apply our best judgment to the situation, but ultimately the ultimate decision on release would not be made, I believe, by me.
Well, since I'm the only one up here, I guess I'm the presiding officer, and my time is almost up, but I have just one other question for you. I'd like to move on to national security, if I might, and we'll remind the chairman that I didn't go over on my allotted time, just in case. The DOJ announced last week that 2 Yemeni nationals charged with conspiring to murder American citizens abroad and providing material support to al-Qaeda will be prosecuted by your office in the Eastern District of New York. I'd like to ask you about your views on transferring terrorists to U.S. soil who have been captured abroad. Terrorists have been tried successfully in civilian courts before, but I'd like to know your opinion about what role you think military tribunals play in handling terrorism cases. Is there any role for military tribunals, or should civilian courts be used exclusively for these prosecutions, in your opinion?
Senator, thank you for that question. The case that you mentioned is being handled by my office. And at the outset, I would note that throughout the process of reviewing that case and deciding how to best prosecute it and where to appropriately venue it, we consulted extensively with the Office of Military Commissions, as we do with all of the cases involving national security defendants who may be brought to U.S. shores and may be brought to the Eastern District of New York. Certainly, I would say at the outset that my position is if terrorists threaten Americans here or abroad, they will face American justice. We have done that successfully in the Eastern District of New York, and I look forward, should I be confirmed as Attorney General, to continuing that strong practice, utilizing all of the tools in our arsenal, and that includes the military commission process. Essentially, Senator, should I be confirmed as Attorney General, I look forward to working with the military and the other executive branch divisions in government to make the best determination about where each case should be brought. Should that determination be in Article III court, I anticipate that the receiving U.S. Attorney's Office would handle it with the skill and dedication that my prosecutors do every day. Similarly, should it be a military commission, they will also handle it with the skill and dedication that they have also shown. I've been honored to have hosted General Martins on more than one occasion in my office and have a positive relationship with him. And should I be confirmed as Attorney General, look forward to continuing that relationship with him and all of our partners in the war on terror.
Well, I'd like to thank you for your patience, perseverance, professionalism, and your graciousness today. You've run out of senators almost.
I seem to have.
I'm going to, in the absence of our chair, there's only one other senator I think that is potentially available for questioning. I know that they're on the floor right now voting. I ran over to get a few questions in. So what I would suggest is that we take a 10-minute recess, if you're amenable, and we'll find from the chairman if Senator Tillis, who's the last remaining, I think, person to ask questions, and we'll see where we go from there. So I think we'll stand in recess for 10 minutes, and thank you again for your graciousness and perseverance today.
Thank you, Senator.
Thank you.